A very good evening to you, ladies and gentlemen. I am happy to welcome you to the first webinar of Series 6 on Basics of Law, titled Re Vindicatio Actions. With this webinar, we are celebrating 25 BSL webinars for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposiums Committee and the president of BSL, Mr. Rajiv Amarasuriya, the co-chairman, Mr. Chature Galhena, secretary of BSL, and Mr. Pasindu Silva, treasurer of BSL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the BSL for all the support and guidance. For today's webinar of Re Vindicatio Actions, we have with us an esteemed panelist, Mr. Sivali Amitirigala, President's Counsel. Mr. Amitirigala is an alumnus of Trinity College, Kandy. Thereafter, he entered Sri Lanka Law College in the year 1996 and was called to the bar in the year 1999. Mr. Amitirigala obtained a master's degree in law from King's College London, University of London. He was awarded Silk in the year 2019. Presently, he is the lecturer in jurisprudence at the Sri Lanka Law College and lecturer in European Union law and international law at the Royal Institute of Colombo. Mr. Amtirigala is presently in active practice of civil and criminal law and is a member of the Avisavella Bar. I warmly welcome Mr. Sivali Amtirigala, President's Counsel, for today's session. To moderate today's session, we have with us Mr. Charita Jayavikrama. Mr. Jayavikrama, attorney at law, was called to the bar in 2015 and is a product of the chambers of Mr. Ikram Mohammed, President's Counsel. Mr. Jayavikrama is engaged in civil litigation, including land law, family law, writ matters both in original courts and appellate courts, Colombo and outstation courts. He has held several positions of the Bar Association standing committees, including the editor of the Junior Bar Law Journal 2021, and he is presently the convener of the Civil Law Standing Committee of BSL. I also warmly welcome Mr. Charita Jayavikrama for today's session. And without any further ado, I invite him to commence today's proceedings. Thank you.
Thank you, Isuri, for the introduction. A very good evening to those who are joining with us today. And as Isuri quite correctly said, today during the webinar of this series and this episode, we are basically targeting on the reivindicative actions, which is, of course, you could classify it as a mostly resorted action in the district courts of Sri Lanka relating to land law. As you may know, the roots of the reivindicative actions we find in the Roman Dutch law, and it had over the years developed and is in the Sri Lankan legal system. And today, during the webinar, with the wealth of knowledge of Mr. Sivali Amitirigala, we wish to take you all through from the basics and to discuss the developments of law, starting from the drafting of a plaint and up to the proving your case as the defendant or as the plaintiff, as the case may be, and to take up what are the defenses that are available, including a comprehensive guideline as to regard to the proof of title, as well as your requisites regarding a reivindicative action. So without a further delay, I would like to invite our distinguished panelist, Mr. Sivali Amitirigala, to take on with this. Sir, to start with this discussion, sir, I would think to have a basic idea for our listeners and the participants, sir, if you could please let us know as to what constitute or what gives rise to a reivindicative action, and thereafter to move on to educate us as to what would be the main features of a reivindicative action, sir.
Good evening, Charita. I think it's evening. And thank you for the introduction, Isuri. Charita, just permit me before I start speaking to thank the President of the Sri Lanka Bar Association for inviting me. And I'm extremely encouraged by these webinar seminars that are continuing, which was continuing during his tenure way before he became president. And I'm very, very happy that it is taking full speed and score now, and we are able to exercise our academic knowledge and to partake in this sort of activity in giving something back to the community, plus we getting something back. So thank you very much for having me. Yes, Charita, if I may just simply say, a reivindicative action has to be identified by these two important, if I say contents. Number one, a particular property or a land, I will take it as a land because most often it is a land. A particular property or land is in the possession of one party. That land is owned by another. Now, this entire exercise or the proceeding of reivindicatio is where the owner of the property will be filing action to recover the property back into him by ejecting the defendant. So, bottom line is there should be a land or a property which is owned by one party, which is in possession of another party. And the owner of the land wants to recover his land from the person who is in possession and therefore institutes action, number one, to declare that he is the owner of that property, and number two, thereby to get the defendant ejected from the property. So, simply put, it's two important contents or elements. Number one, ownership in one party. Number two, possession in the other. Now, when we talk about it further, we will find instances which go beyond the normal example of a reivindicatio, which I just said now. But a majority of cases, if I may say, in the district court come on the basis of a declaration of your ownership and then to ask for an ejectment because they have been deprived of the possession of the property. What are the most important features of the reivindicatio action is there is no need on the part of the plaintiff or the owner to have any prior possession to file this action. You can merely demonstrate and prove your paper title in court, which entitles you to all the rights of ownership. And then the burden shifts to the defendant. We will talk about it when the lecture is going on. It shifts to the defendant. So you don't need a requirement of possession of the owner because actually the action is filed at a time when the possession is not with the owner. So therefore, I would say the most important two features or the requirements, more than the features, requirements, is that somebody should have ownership of a particular property and somebody other than the owner should be in possession and the owner is filing action for the purpose of ejecting the other party, which would be the defendant, and to obtain possession. Simply put, I think I could define a reivindicatio action in that way. I didn't go into the Latin terms and so on because I think this is meant for people who are in the practice in the first 10 years and even others as well. So I'm just saying, you know, all your Latin and Roman law and all that, that's a different thing. Just come into the basic characteristics first. Understand what are the elements of this action. So when somebody comes to you for a consultation, just see what is the issue. Is somebody trying to recover a property which is owned by them and they want to go to court? Then you can see whether who is the owner, who is in possession, and then can we prove ownership and then shift the burden to the defendant so that the defendant can say, how am I or how is he in possession? So I will talk about the defenses later on. So to start with, I think I would basically define reivindicatios in that particular manner.
So since you discussed about one party has to have the ownership, for the better understanding and more clarification of our participants, if I may say, for example, if there are co-owners,
Yes.
would you be pleased to explain as to what would happen and what is to the extent to which a co-owner could exercise his rights in terms of a
Absolutely.
reivindicatory action?
Absolutely. That's a very good question, Absolutely, Charita, absolutely. Because some lands are owned by co-owners. So if one co-owner files a re vindicatio against a trespasser who's in possession of the land which is owned commonly by so many people, but one file, that person should be able to get a declaration for that particular share that person holds and to get a declaration to eject the trespasser. The word should be trespasser. There can't be a re vindicatio filed by one co-owner against another co-owner for the purpose of ejectment. But as far as declaration of the share of the owner, yes, but not for the purpose of ejection. So, I mean, if you want a declaration or if you want to divide the land, you would bet the better remedy would be partition. But I think it's very important to touch on this. Even a co-owner can proceed against a trespasser to get the trespasser ejected. And there have been many instances, which I will discuss later, about greater and lesser relief, where we can see that a co-owner would and has been entitled to get a declaration of his share and then to get the trespasser ejected. Because the trespasser has no right anyway in the co-owned property. So he needs to be ejected once it is proved that he has no ownership and that he's a trespasser. I hope I answered your question, Charita.
Yes, yes. I hope the participants are also quite clear on that. And also, we have allocated a question and answer session.
Yes,
And at any time, you can raise your hand in the comment box and we will divert to you. So, sir, moving on, we would like
yes,
to now the reivindicative action, it involves a property. Therefore, to
yes,
go to court, we would have to identify the property.
yes,
So, if you may please brief us on the
yes,
aspect of identifying the
yes,
property and how the cause of action should be defined.
yes. Correct, correct. Thank you. First and foremost, I think, as I said earlier, the essence of a reivindicatio is the ownership. So it's very important, first and foremost, that somebody who wants to recover the property or to file a reivindicatio to show that he or she or it is the owner. So now in Sri Lanka, we have ownership resembling from deeds which have been executed in terms of Section 2 of the Prevention of Fraud Ordinance. So there you really need to have your deeds. And if you don't have deeds, you can also, in certain instances, come by way of, let's say, a final partition decree where a particular property had been given to you by a court order. So the ownership of the property is number one. So you'll have to decide what is the evidence that you have to claim ownership. Let's say there had been a partition, a bigger land had been divided, and this particular land has been now divided and given to a particular person by the name of A. A is not in possession. Let's say somebody he has put with leave and license has now stayed on it and doesn't want to go. So he identifies that the land came into him by a partition, final partition, and that final partition decree will be necessary as a piece of evidence in order to start up where the title actually starts. I mean, this is not like a partition where you need to go into a title deeply. All what you need to show is your ownership. So your ownership sometimes can be from a final partition decree. Maybe it went to your father. Father had executed a deed in your favor. So it's you who's coming to court. Then you will have a decree, plus then you will also have a deed in your favor, which you will want to also display in as evidence, because otherwise you can't continue with the partition. Sorry, the reivindicative action. The plaintiff has to have ownership, and he has to continue to maintain ownership in a reivindicative action. So number one, you need to identify what sort of ownership do you have. As Charita earlier said very correctly, maybe you have a co-ownership. Then you'll have to prove your share in the co-ownership. So that's very important. Secondly, the property has to be identified. This is very, very important, because most of the time the defendant would not admit the corpus. So if the defendant admits the corpus, you have no problem because, corpus is identified. But otherwise, if the corpus is not identified, you'll have to get a commission from the court to get the land surveyed, and the surveyor will submit what is called a plan and a survey report. So that will have to be marked in evidence if the other party or the defendant is disputing the corpus. And because it is marked in evidence, if it is marked subject to proof, I think it is prudent for the plaintiff to summon the surveyor to give evidence, especially if there is a discrepancy as to the extent or to the four boundaries of that particular land which is surveyed. Because if there is a discrepancy with the four boundaries, let's say three boundaries tally with the boundaries of the survey plan, there is a dispute as to one, or all boundaries tally, the extent has gone down or extent is reduced. It will be important if the defendant is disputing the corpus for you to get the surveyor to give evidence, because the surveyor would be able to explain as to how it has happened, and the surveyor will able to say the land that they have surveyed is the land that is the subject matter of the action. Now, in a partition case, of course, the survey indicates that it is, but in here too, the surveyor will be able to say this is the land which the plaintiff seeks to get a declaration that he is the owner. and and what is important, very much so, is that if the defendant is in possession of your land and he owns the land which is adjacent to that land, the surveyor who is under a court commission is able to go and survey because it's on a court order rather than you doing a private survey. It's very important to keep that in mind. So, if by chance the other party is disputing and so on, he'll report it to the court. So it's very important to understand, depending on the facts and the circumstances of each case, and depending on how the defendant is reacting to the corpus, I think proof will have to be educed, and it will be best if he is disputing for you to call the surveyor so that the surveyor can. Now, I want to also say this. Let's say if you're the defendant and you are disputing, there are tremendous amount of cases we see, they just dispute the corpus. If you dispute the corpus which is of the plaintiff, you need to bring an alternative survey to survey and say it is not the land what the plaintiff wants to get a declaration, but it's the land that you're saying. So it all depends on whether you are disputing the corpus. If you are disputing the corpus, only I would think you should go, because otherwise, if you're not disputing the corpus, and I will later on go to certain defenses, in the revindicatio, it should be understood as if you're not disputing the corpus. I will tell you when I come into the defense discussion. But it's very important at the very outset to identify the corpus. There are many cases, and I think the cases are also given. I think there will be a handout that will be given to you once the lecture is over. I think this Latif versus Mansoor 2010 2 SLR page 333 is a case very clear about identifying the corpus very clearly as to what the reivindicatio subject matter is. Third element of a reivindicatio, in as far as proof is concerned, I think, is to show that the defendant is in possession. For the simple reason, if you don't know who's in possession, against whom are you going to get an order to eject? So you need to know who's in possession, and that he or she or it is in possession of your land. So for that purpose, when the survey is done, you will see that he is in possession and he will say, I planted this tree, I did this, and so on. That also establishes possession. You see, but it's very important to also state mere statements of a person saying that I have planted this and I've been here, would not by itself be a piece of evidence to establish prescription if he's claiming prescription. That's very important to understand. But you'll have to assert your right. So obviously, the defendant is in possession, and you'll have to get an order to complete the case. That is to get a restoration of your property. That is to eject the defendant. So it's very important that the defendant occupying the property belonging to the plaintiff and thereby interfering with the ownership rights of the plaintiff needs to be identified and sought to be ejected for the purpose of restoring the land back to the owner. So I would think three important elements to prove would be the fact that you have ownership, that your land is identified, and thirdly, that the defendant is in possession. Usually, before we start filing the action, you will have a consultation. And I would tell any young lawyer or for any lawyer, I think consultation is very important. It is in this consultation that you'll need to have all the box ticked off, thinking, do you have the ownership? How are we going to identify this particular land? And what are the modus operandis that you're going to take? And with regard to the defendant, it's very important because there has to be a cause of action accruing. And you have to lay that down in the plain. How did it come? Let's say somebody has come into your property with leave and license and is not leaving. Then you'll have to go to the police, lodge an entry. Somebody enters into your land, let's say, like an encroacher. You'll have to go to the police, lodge an entry, and then you'll start the police to sort of investigate and say what is happening. So those statements to the police will be important. And that day that your ownership rights are disputed would be round about the date where the cause of action accrues. The cause of action needs to be very clearly laid down as to when your ownership rights have been disputed in the form of, let's say, some encroachment, or in the form of a party saying, I am not going to go, I'm going to stay and not hand over possession to you. So, depending on the facts again and the circumstances, I think you need to identify how to identify the cause of action, and the cause of action will have to be brought into the plaint. Now, when you are going into the plaint, you'll have to talk about ownership. You'll have to talk about how the land has been identified. And if you haven't, at the time of filing the plaint, got a survey done, you can ask for a commission from the court. And thereafter, once the survey is done, you'll have to amend the plaint. Then you'll have to talk about how the cause of action accrued with the defendant disputing your ownership rights. And then you go into what is called a prayer. Before you go to a prayer, sometimes, let's say, if it's an encroachment and they're building or they're destroying your cultivation, then you'll have to think about interim relief as well. So your plaintiff will, so your plaint will have paragraphs indicating you asking for enjoining orders, proceeding to an injunction in the event that there is a nuisance that is continuing, and you will need to halt the nuisance pending the action. So all that will have to be decided, discussed over a consultation. I would extremely and sincerely advise lawyers as an extreme measure to have a consultation and discuss all these elements before you file the action. Because, you have to really think about how you're going to connect the dots. When I say dots, connect the elements, and how you're going to talk about the accruement of the cause of action. Because sometimes it could be a few years ago you knew the person was in possession, but you made the entry to the police station, but you didn't take any action. But yet it has not come to that 10-year period, let's say. So you need to really identify, why are you coming to court now and why didn't you do it at that time? Perhaps you ask that person to go and the person says no. So it's very important to understand how the cause of action comes in, and you will have to justify that. So you have to understand because the defense can take up the position of prescription. So you need to understand that 10-year period of adverse possession will have to be taken into account if the defendant is a person who you might think is going to assert that right and does not have any superior title above you. So that's very important. So to sum up, I think it's ownership, identification of the property, and then cause of action on the basis of person disputing your ownership and the person is in possession.
Thank you very much, sir. Now, since you mentioned about the cause of action and as well as identifying the subject matter, rather the property, sir, would you be pleased to explain to our listeners, the participants, as to the application of Section 41 of the CPC as to how a property in the plaint itself? Now, you very elaboratively you discussed as to in the real world scenario or in the realistic means how we should do it at the trial. But prior to that, sir, since we have seen so many objections being taken that the land is not described in terms of Section 41, would you be pleased to explain the application of Section 41 as well, sir?
Thank you. Thank you very much, Tarit. I think that's also an important element that you know, if you take section 41, it is the basis upon which the identification of the land must happen. I'll just read it for you for explanation because I have it. When the claim made in action is for some specific portion of land or for some share or interest in a specific portion of land, then the portion of land must be described in the plaint so far as possible by reference to physical metes and bounds, or by reference to sufficient sketch maps or plans to be appended to the plaint, and not by name only. Absolutely correct. That is why I think it's very important, as Charita said, because in the plaint, you'll have to identify the corpus, and that identification will be manifested, that's the word, by the schedules to the plaint. Schedules to the plate is very important. You'll have to think about the most recent plan that has been there or the plans that have existed. Let's say if it's a land reform, or let's say a land that has been taken over by the land reform and given back to you, let's say with under the gazette, let's say, and there is a plan. You'll need to talk about the gazette. You'll need to put the plan, and the land needs to be identified, let's say, with meets and bounds, saying, you have to identify with the boundaries, and you'll have to lay down plans, or I mean sketch and maps are there, but plans are there in the present day. So you'll have to append them in the plane. You just can't simply say it is land called Devatagahavat or something. No, all that must come in, but you need to understand. But because so long as the subject matter can be clearly understood by the plaintiff in terms of section 41, I think you are all right, because there is a very important feature that you need to remember. If you don't, the judgment will not be able to be executed, because in the execution will happen in terms of your identification in that particular pleading. So it's important to understand the case of David versus Jnanavati, 2002 SLR, page 352. That, of course, came with regard to, I believe, mm, uh, um, a situation where the strict compliance of section 41 of the Civil Procedure Code is said to have been necessary. It was stated because otherwise it would impede the fiscal for the purpose of executing the judgment. So it's very important. That case involved a servitude. But what I'm trying to say is it's very important. But many other cases has since then gone in saying the importance of section 41. Section 41, I would think, in my opinion, is a foundation to your plaint in identifying, describing your corpus, and explaining in the schedule. Clear, Charita? I hope I answered that.
Yes, I believe so, sir. Since now you also mentioned about the police complaint
Yeah,
regarding a dispute, you
yeah,
mentioned about police complaint. So more often than not, sir, we also tend to see the moment there's a police complaint, the moment there's a tendency of a breach of peace, the police will resort to file an information under Section 66 of the Primary Courts Procedure Act. So I would think it will be prudent and for the sake of completeness, sir, at this point to discuss the scope of Section 66 applications and the outcome of it.
Yes, I thank you, Charita. That's true. That is very true. Because as soon as you make the complaint to the police, you also will have instances. I think there will be a larger amount of instances where a breach of peace is about to happen. Because these land disputes, boundary disputes are very emotional issues for Sri Lankans, and I think people who live, especially, owning that little piece of land and they feel somebody is encroaching. So, what the police will do is that the police will file action under Section 66 on the basis of under Section, I believe, 68(1) or 68(3), if I'm not mistaken. That is either to say that you have been dispossessed from the property or possession, or that your possession is interfered with. So, if that happens, then a 66 action will go. Now, it's very important to understand this. A 66 or a breach of peace or an action under Section 66 of the Primary Court Procedure Act is purely a temporary decision when the magistrate gives a decision on that, and that decision will only hold a breach of peace or the impending breach of peace happening. It will only prevent it. That is for parties to say you can't just go and by force take certain things, behave yourself, act in terms of the law. So what happens is when the police files, then they will be noticed, they will be called to court. Affidavits, cross affidavits will be filed, and the parties will be asked whether there is a settlement, and if there isn't, then of course written submissions, and the court will decide to whom the possession should be granted. Now, as I said, that order will be a temporary order. If you go into the Primary Court Procedure Act, there is no right of appeal. Only a right of revision will ensue in the event that there has been something which shocks the conscience of the higher court, which is the High Court. So there is no right of appeal as of right. The reason is it is by all means a temporary order. And I would think, with practice, I must say, whenever I find a 66 action also filed, I at the same time get the parties to file a re vindicatio if there is clear ownership. Because in 66, ownership is not an issue unless of course both parties seems to be having some ownership right, which they will. Otherwise, they'll go by way of possession. Deeds will be compared in the event it is necessary to do so, but they are not necessary to be gone into because it's possession that has been looked at. So it's very important if you have the deeds and if somebody is in your land and there's a 66 file, maybe since he was in possession and that you tried to put him out, court will give him possession under Section 66, saying that you have dispossessed the person just 2 months before filing of information before the magistrate court. That is to restore. Or else if you have disturbed, then say maintain peace. So if that happens, then you will have to start a re vindicatio all over again at that point of time. I think this is purely my personal view. I think if you have good ownership rights, you should file actually a re vindicatio. And if a final or a order has not been given by the Honorable Magistrate under Section 66, let's say there is only an interim order given under Section 67, subsection 3, let's say, uh, I think the district court, if a interim relief also or order has not been given by the this magistrate court, the district court can grant interim relief if the case is going on without an order from the magistrate court as to whose possession. However, if an order has been given in the magistrate, interim relief in the district court will not be able to be given because that will clash with the magistrate's order. So the main reason is to prevent two orders from clashing with each other. So then, of course, you'll have to go and go to the sort of the finality of the reivindicatio and get your property back. Otherwise, what is important is while the 66 is proceeding, you can proceed with a reivindicatio, and if there is no order from the magistrate court, I don't see any reason as to why an interim relief can't be granted if by chance the person is in the premises and is resorting to all sorts of activities to change the nature of the corpus, or for that matter, I would think make that illegal possession a source of financial or income, you can always resort for an interim relief. I stress again, if there is no order from the magistrate court, but yet it's pending. Now, if any one of you wants to refer this area, which has been explained very clearly, which I still refer, is that there is an old judge's journal where His Lordship, Honorable Justice Sosa, has written an article on interim injunctions. There is a particular section relating to this overlap. And in there, it is very clearly mentioned, so long as there is no order from the magistrate court, whatever order that comes first will take precedence. So if the magistrate court has already given an order relating to possession, you can't get an interim order against that particular party because they are already in possession. So then you'll have to go a full trial with regard to a reivindicatio and get an ejection. But let's say the case is pending, it's going, then there is no order. So perhaps the interim relief order of the district court will be the one that comes first. So in those instances, you could. Please refer that if you get the opportunity. It's a very fine article. I might also say this. I haven't come across a better article on interim injunction still because very comprehensive. It is very educative. And I know there are instances where lawyers from other jurisdictions, I know one who's a barrister in England who still has the book and still refers to it, even though it's a Sri Lankan law. The basic principles enunciated are very important. I'm not saying that it is applicable there, but I'm saying is the academic value of how we could derive by reading it. So I would immediately put that as an essential reading if you're really interested in this area. So it's very important to understand that section 66 will come in, and if it does come in, this would be a way to deal with it. If you don't have an ownership right and you simply have nothing but possession, then I think you'll have to go with the magistrate court order, and the other party who will have ownership will file action in the district court to recover, which is the prudent thing to do.
Thank you very much, sir. Now, moving from that point onwards, sir, now we have covered the area as to how we should, from a client, when the client comes for us, comes for a consultation, to identify the basic elements as you explained, and then thereafter to draft the claim. As you said, we have touched upon the facts that how the schedule has to be drawn up, and then thereafter, when going to the trial, slightly we have touched the requisites of getting a proper plan and the calling of that witness. So therefore, sir, before anything else, I would think it will be prudent if we could educate our attendees as to how are we going to prove our title, because in view of the recent amendments and the application of section 66, 68, with all those things put together, sir, I invite you to educate us as to the application of proving title. This is paper titles.
Yes, thank you. I think that's also a very important thing that I think you stress, because consultation comes into handy in this instance. You really need to identify what are the ownership documents you have. Let's say it could be even a grant under the Land Development Ordinance. It could even be a deed. It could even be a partition decree from there, which there are other deeds that have come. I would think a proper title search is important prior to we really deciding. I think even before we go into the plaint, I would think it'll be important to do a title search also, just to get an idea that we don't have any other deeds that have been registered which will have priority over us. So it's very important to do your title search and enter when you are going to go to court, enter in your list of documents all those documents, whether you will put them in the trial or not, you list them. It's very important that the chain of title starting, you don't need to go into the originality of anything. You will just have to say, this is the deed I have. And there has been owners who have preceded before. Let's say you have those deeds also, you can mark those deeds. If you don't have those deeds, let's say there are extracts from the land registry, they will be relevant to you. So you'll have to decide, depending on the facts and the circumstances, how you are going to nicely line up your documentation with regard to ownership. Now, I will also say this. Let's say there was a court order by which a particular land was said to have been given to a particular person because that person has asserted prescription and has got an order of prescriptive title. Now, that is a title that has been given by court. Subsequent to that particular court order, there might have been deeds written. Right? It's very important. But I think it's important to stress this point. Prescription has to come from a court order. It can't be just prescribing. Only thing in the plaint, you can buttress your paper title by saying you have been in this land for so many years. You can buttress it. But I think priority must be given to the paper title that is there. It's very, very important. Because at the trial, at the trial, you will have instances. You will have instances where when you are now, this is what it is. Your list of documents and the list of witnesses are all according to the law, let's assume, under section 121. There's no problem. You start up the trial, issues have been framed, they are disputing your ownership. Anyway, you will have to show your ownership because in reivindicatio, the burden is on the plaintiff to prove title. And this burden, you need to understand, does not involve a mathematical precision of your ownership. It needs to be proved on a balance of probability that you are the owner. For that matter, let's say you have some deeds coming up to your own title deed. Let's say when you are tendering those title deeds, they admit, let's say, out of the 4 deeds, they admit 3. They have even said that, let's say, as an admission. And let's say when you're marking them, they are not objecting because obviously they have admitted that. But they're disputing your deed. At the time that your deed is marked, let's say, in terms of section 154 of the Civil Procedure Code, the other party is saying, I am objecting to this and may this be marked subject to proof. Now, at that moment of time, even if it's just one deed, you need to prove the execution of that deed. So it's very important that the execution will have to be proved in terms of section 68 of the evidence ordinance for you to proceed. Because when I say proceed and get an order in your favor, because under section 101, the burden is on you now to prove that this particular deed has been executed because they are challenging the execution. It's very important. Let's say The notary is dead and the witnesses also are dead. What happens then? Let's say the deed is beyond 30 years old. It's more than 30 years old. Then section 90 of the evidence ordinance will come into operation, which says a presumption where any document purporting or proved to be 30 years old is produced from any custody which the court in a particular case considers proper. So that is important. The court must consider proper. The court may presume that the signature and every other part of the document which purports to be in the handwriting of a particular person, in that a person's handwriting, and the case of a document or attested that it was duly executed and attested by the person by whom it purports to be executed and attested. So obviously, it's very important to understand that section 90 will come in your assistance or in your favor only if the deed is 30 years. And that's also a presumption that the court would draw or should draw. And it should come from the proper custody. I want to stress one point. A certified copy is not going to suffice. You'll need to tender the original of the deed if you are going to go under Article or Section 13. Because a certified copy is not an original, it is only a certified copy. So it's very important. If I have my original deed, I am entitled to keep my original deed and I am tendering it from my custody as it is. It's very important. I just want to stress that. And it's if it's more than 30 years and you can't. But I just want to also say this. Sometimes we are very complacent. Today they objected to the deed and the case has gone down for trial, let's say in 4 months' time. We have a case tomorrow, we forget the whole thing. Now that is what you need to be careful. You need to make a note today or get your junior, or you, if you don't have a junior, you're a young lawyer, you need to understand how you are going to get this done. So then maybe next time you can, before, of course, you need to be mindful when they are and you have finished your evidence and then the deed has been objected to, best is get summons on the notary. So you need to understand how the next step needs to be taken depending on how the defendant is reacting to your documentary evidence that is tendered. It's very, very important. Let's say you tendered a grant which has been given by His Excellency the President, let's say, and they are disputing it and they are saying subject to proof. Then you'll have to prove it. So you'll have to prove it by summoning a person who is having authority to speak about it and say, or to authenticate that and say, this is something that comes from this office. Let's say there has been a subsequent deed that had been executed with the permission of the GA to somebody who is now the plaintiff. Then too, you'll have to prove how it was executed, this is a deed, by summoning those officials or the notary who executed that deed and proving it. It all depends on the type of documents that you have. Let's say it's a plain deed, just get the notary. It's very important once the notary comes and gives evidence. As far as execution is concerned, the execution stands proved. And, even though all possible requirements under the notary's ordinance have not been taken place, let's say, that is not a ground to invalidate a deed. That is not a ground that the deed is invalid. So the deed will have to be proved to have been executed. So these are the questions that you need to understand. Because the plaintiff must prove his title to the land or the property so that he can establish that he has superior title to that of the defendant. That's one. Or that he has sufficient title which can vindicate against the defendant. Those are the two. So it's balance of probability. All what you need to do is I have superior title about him, or I have sufficient title to get a declaration over him to get him ejected. that needs to be the burden of proof that should be. It's not beyond reasonable doubt. Certainly not. It's definitely on a balance of probability.
So also, I think most of the attendees also would have come across
Yes.
situations in courthouses where we see some of the defendants say when we mark a deed, they say the execution is admitted.
Yes.
They don't dispute the execution.
Yes.
But the contents, they put the blame or the burden on us to prove. Will you be elaborate on that aspect, sir, when in a reivindicative action, where they say the execution has happened, maybe for instance, where they have also signed, but on the other hand, they say the contents would be.
So if sorry, Charita, sorry,
Yes.
I
No,
interrupted you. I'm
yes,
sorry.
yes. Proceed, sir, yes.
So if it is something like a fraud, let's say it's or a fraudulent deed,
Yes.
they say we signed blank sheets. It is very important if you say blank sheets, they sign only bare papers, that you don't only summon the notary, you need to summon at least one attesting witness to prove it. It's very important. I think Hilda Samaravikrama's case is, I think, authority on that. So it's very important, I think, for you to do it because the execution is admitted, but the contents is disputed on various grounds. It depends on which ground they are disputing it. Let's say if it's a fraud on the basis of fraud, so it could even be instances where there has been police complaints made. Maybe there's a magistrate court going on the basis of some fraud relating to a transaction. So all those are relevant. But I think it all depends on what cause that they are challenging the content. And based on that, you'll need to prove that as well. Let's say I just took the blank papers saying that we just signed it. We signatures are ours, we signed it. So then you'll have to get to say this is what you did, this is what happened actually. Notary alone, I think there's a case, I think Babanchi Hami, I think, if I'm not mistaken. It is cited in the Hilda Samaravikrama's case. You have to prove it by bringing at least one attesting witness on your part. So that is only specifically saying with regard to, just signing bare documents or just signing a bare sheet of paper. But it could be many other reasons. It all depends on that.
So moving from that point onwards, sir, can a party file action, a reivindicative action, based on the prior peaceful possession?
Absolutely, absolutely, absolutely. Every time a person has proved their paper title, the defendant or the burden of proof shifts to the defendant. But the only exception there are two exceptions. Two exceptions that are in existence is one, where the defendant admits the paper title of the plaintiff. Then the burden shifts to him to show why are you in possession. The next one is where a person who has been in prior possession, peaceful possession, has been, let's say, dispossessed by someone. He will file action on the basis of prior peaceful possession. And then the defendant will have to prove, his burden of proof will have to be, I am the owner of that property, therefore I am entitled to a declaration. If the defendant fails to do so, then prior peaceful possession will have to be restored. So that is also one which is an available requirement or a available situation that would come under reivindicative actions. If any one of you wants to go further into it, I would think one of the very good explanations of this I found in Professor G.L. Pires' book, The Law of Property in Sri Lanka, Volume 1. I think it's a very good book for anybody, whether you are new to law or whether you have been practicing for a period of time, if you read the re vindicatio action segment or the chapter, which is in the book, I will tell you the chapter also, then you can chapter 11, you will find prior peaceful possession being explained as one of the important elements in the discussion of re vindicatios. And there are several cases also. There are several cases that you can also go through. I believe Mudalihami versus Apuhami, 1 CLR, page 67. Medankara Terun versus Charles Dias, 7 Supreme Court Circular 145. Khadira Ma Thambi versus Arunugam, 38 CLW, page 27 are some other reference I've given. I am aware that there has been a recent judgment also, when I say recent, few years ago, probably about 2 years ago, from our superior courts also on this, which I was trying to find, but I couldn't. But there is, I believe there is. I remember reading one of that. So that is also a very valid element that can be made use in as re vindicative actions, Charita.
So moving on to our next point now, we talk of reivindicative action on the presumption, or rather on the premise that we are the owners.
Yes.
We have ownership. Then, sir, it will be ideal at this juncture to brief our attendees as to, if you are an owner, what rights do you have as an
Good.
owner? What are the important features of ownership? How do you explain to the world you are the owner, and what are the attributes of a ownership?
Thank you. Ownership has its own sub-rights. And there are three sub-rights, I would think, in ownership. One is the right to possess and to recover possession. I mean, I have a right to possess my property and to recover it from somebody who is encroaching it or is trying to take the property or is occupying the property. Because I have a right to possess it, the second sub-right is the right to use the property that I am possessing and to enjoy the property. So I will be able to, let's say, put up a house, a swimming pool, if you want to say. If you want to go into something less luxurious, you can put, let's say, something like a hut or something. Whatever you want to do for the purpose of enjoyment of the property and the use of the property, you can. So cultivations can come. You could have livestock being used for grazing and others in your land. Perhaps you could have a livestock farm. You could have a tea plantation. Whatever you want for the purpose of using that land. Or even in the modern day, you see, you could also give your land, rent your land to some telecommunication tower. I am using my land for that purpose, you can say. Then the third sub-right is I have a right also to sell the land that I own. So possess and to recover possession, number one. Number two, to use and enjoy. And number three is the disposition. I can sell it if I want. So these three rights are very, very important. So once the paper title of a party is proved in a re vindicative action, the right to possession is presumed because ownership is entitled of these subrights. So possession is anyway presumed upon proof of paper title. Lokumanike versus Gunasekara, 1997, 2 SLR, page 281. Liza and another versus Simon and another, 2002, 1 SLR, page 148. Patirana versus Jayasundara, well-known authority, 58 NLR, page 166. A few authorities that come under that. So those are the most important rights. Actually, if you go through Professor G.L. Peiris's book on the law of property, volume 1, uh, after reading Re Vindicatio or even before, if you go to chapter 10, just one before Re Vindicatio, is the attributes of ownership. And you will see that these sub rights that I just mentioned exist in it. So those are also essential reading for you if you can, because I happen to be still reading those whenever I feel I need to update my knowledge, because I think it's very important to have some sort of fundamental in it. Because now, as when Charita is asking me questions, if you also are a practitioner, certain things start coming up into your mind. At the same time, what you have read, so you need to have your textbooks. I'm not just going to say this is the only textbook. There are plenty you can use. You can get used to one that you are very comfortable with. So if you want to, you can go. And there's a book relating to law or property law, which is written by Dr. Vijay Das Rajapaksa. You can use that. And also by Mr. Abdul Majid. I think that's also another book that you can make use. All these books are very important that you can utilize. And there are plenty of case decisions. That's what I like to read, because on a daily basis you get case decisions coming from the Supreme Court, Court of Appeal. Plus, there are many, many case reports like the old ones that you can see. Some of the most important features that are valid today have been spoken so many years ago. So all those are sources of law. So I believe those are the three sub rights that ownership would entitle.
Sir, we discussed, I think you mentioned when talking about the calling of a witness as to how a
Yes,
witness should be. I just managed to find the reference, which is Francis Samaravikrama versus Hilda
that's
Jayasinghe.
right.
Sorry,
Hilda
that would be the
Jayasinha.
case. That is 2009, 1
Yeah.
SLR, page 293, sir.
Thank you very much, Charita. Actually, I'm so grateful to you. Thank you very much, because that is the reference, and I'm very thankful to you because that case talks about it.
Talks about.
I believe it is Justice Salim Marsouf's judgment, if I'm not mistaken.
Yes, sir. Yes. Yes.
Honorable Justice Salim Marsouf. So there you are. So I
Yes,
mean,
yes.
just
It's by Justice, Honorable Justice Salim Masuk, sir.
yes, I believe so. So thank you very much again. So that will lay down.
So now we have for all this time, sir, we have been talking about the plaintiff in a reivindicatio action. So now turning on to the defendant, because
Yeah.
we could be retained for the plaintiff or
Yes.
for the defendant. So in the event of a defendant being our client, sir, I would like to invite you to address our attendees as to what would be the defenses, or rather what would be the cross claim or a claim in reconvention that could be set up by a defendant in such a case, to go into that aspect of reivindicative actions.
Yeah, that's absolutely very valid what you said. I mean, I'll give you my personal view first.
Okay.
Most of the time, we are retained by the plaintiff. So we are used to sort
The
of,
plaintiff.
talking about the plaintiff's case. Sometimes the defendant's case is actually no case. So sometimes when you have an instance where there is really no way you can go, you'll have to tell the client it's actually quite difficult. But because the point is this, if you have a chain of title which you are going to fight against the plaintiff's chain of title, which is actually superior to the plaintiff's chain of title, I can understand that. How might that happen, you might wonder. For a moment, let's say your deed is registered prior to the deed of the plaintiff. Now that's a very good defense. You can say, my deed, I have a ownership right. My deed is registered prior to. That's one. But a majority of cases, Charita, majority, I must say, the defendant would take the issue with regard to prescription and say, I have been in possession for 50 years, 40 years, and therefore I have prescribed this right. And they can also put a cross claim, as you say, and a prayer saying, please declare this as a property that I have prescribed in their hands. So once that happens, it's very important to understand if you are appearing for the defendant, you'll have to sit down and talk with your client because prescription under ordinary circumstances is actually making legal an illegal situation. This is fundamentally important for lawyers to understand. And the law will always be interpreted in line in favor of the party who has a legal right. That you have to understand. That is how it is. But the law permits under Section 3 of the Prescription Ordinance for you to prove a long period of possession coupled with adverse possession, whereby an independent title you have now created as a result of adverse possession. Before I go into the evidence that you are required to furnish in the court, may I say in the plaint itself, you'll have to take up the position when your prescriptive position comments. That's number one. And again, as I said earlier, this part of what I'm saying is purely my personal view. I have seen when I go into appeals that sometimes the defendant has taken contrary defenses in the answer. What do I say a contrary defense? I am claiming prescription as the defendant, let's say. I think, again, I'm saying if you are claiming prescription, you are claiming prescription to the land that the plaintiff says that person has paper title. So it means two things. One, you are claiming prescription to that particular land which the plaintiff also claim as in paper title, which means how could you dispute the corpus? So sometimes in the answers I have seen, you don't admit the corpus, you are disputing it. And then you also say, I have prescribed to this particular land. Now you have to be careful with that. Because I have prescribed this land, then I know the boundaries. Those boundaries are the very boundaries that he's claiming because on the basis of his deed. He has got a deed, but he's got no possession. I have been in here. And these are the boundaries. And it's always better for you to, in those instances, to prove how you converted your possession from mere possession to adverse possession. It doesn't have to be violent all the time, but it certainly has to be inconsistent with the ownership rights of the plaintiff. What does that mean? The second issue is, if you are claiming prescription, again my personal view I'm saying, you can't dispute the plaintiff's rights to the property as an owner. You are disputing his rights as owner now because that's where your adversity begins. So you say, I admit his paper title, but I've established a title independent, adverse to that title. So if you are pleading prescription, I think it'll be wholly contrary in the answer for you to, number one, dispute the property, and number two, to say, he's not the owner. Then the question is, against whose rights or whose ownerships have you established prescription? So it's very important as to clearly identify what is your case. You can't be fighting 3 or 4 battles in the answer. You have to fight your battle on prescription. Then say, this is the land I am in occupation. These are the boundaries. I have been in possession from this date onwards. I have not allowed any one of them to come and assert their rights. In fact, I have prevented them. There have been instances where they have tried to come in. I have prevented them in all those instances. And see how I am maintaining my domain, not merely by saying I planted this, planted that, have documentation. You can also have instances where you probably would have leased out that particular land to somebody else, and those lease agreements are there. There are people who have, let's say, put up towers or whatever, put up buildings, and who are on rent. Now you are saying you are for over 10 years. It's very important for you to show circumstances of adversity as opposed to mere possession alone. It's very important. If you have paid rates and so on, those will be relevant, but those won't be per se evidence of prescription. It's very important. I want you to keep this in mind because read section 3 of the prescriptive order. It says against the ownership rights of the plaintiff or the claimant. Remember, when you go through that, you will see it. So, and also in normal language, I have to establish an independent title against the ownership of the owner. No? So how can I say he is not the owner? Then against whom have I prescribed? So please don't take these contrary defenses. Actually, I have seen in the Honorable Supreme Court, the arguments are hardly brought into the very specifics because the answer in the district court has so many grounds that you have taken. And you're batting with your cross examination all over. You're disputing the corpus, then you're saying you have been in possession and all that. Identify your case very clearly. So it's very important if you're going on the basis of prescription, these two contrary defenses will have to be in mind, very much in mind. That it also could be that that you might say, I have prescribed one part of that property, and the other part is my property. I have occupied this property. Yet for all, it will be part of that particular corpus and the owner of that particular land. So these contrary defenses, you have to be mindful. That's something that I, of course, would like to share with you because I believe there is one judgment in the Court of Appeal by Honorable Justice Salam, who says that when a party disputes the identity of the corpus and has claimed prescription, that is a contrary defense. I found that. Then there is a Supreme Court judgment by His Lordship Honorable Justice Cicero Diabru, who have said that you cannot dispute the identity of the corpus if you are claiming prescription to that corpus, which is very right. Which is very right because it's actually a waste of time and a waste of energies on the part of both counsel because you are now not really addressing the most important point. You're going all over. So it's important to understand what does section 3 of the prescription ordinance say and gather evidence to prove. So you need to prove when you actually, or you need to state and prove when adversity starts. May I also say this? Sometimes the plaintiff and defendants can be relatives. And you might enter a property with leave and license, permission. So it's very important for you to say when did you change that character and adduce adversity and evidence of adversity after that. So it's very important because the answer is your foundation if you're the defendant, that you take up a proper foundation against the plaintiff's title, against the plaintiff's title. Or else you can say, look, I am not the owner, plaintiff is not the owner, some third party is the owner. That also you can say. Right? That also you can say. So it all depends on what you want to say with the evidence in your answer. If you are going to dispute the property and say, look, there is no prescription, but this is my property and this is not what the other property that the plaintiff said, get an alternative survey that show that. Also, I would think in situations where you are claiming prescription, there would have been instances where there had been cases, and maybe they have lost and they have not taken any action thereafter, but you have continued in so all those things will be coming as stacking into your period of time in prescriptive position. So since prescription is very subjective, Charita, it all depends on again the facts and the circumstance. I
Okay.
hope I touched on the basic areas which would be beneficial to the viewers.
Yes, sir. Thank you very much. And also, since you touched upon the fact, sir, that we can't take contrary positions in our pleadings, I would think in just few seconds, if you could tell our listeners as the concept of you can't blow hot and cold at the same breath. So that had been a long line of series of authorities
Absolutely.
where the appellate courts have constantly held to in this regard. And I think you will agree on that.
Absolutely. Absolutely. I think you're very right. And I know you appear in the appellate courts. I know you are very versed in this because this is a ton of time. It's a ton of time of all courts. Because I must be very, very clear with this. The instructing attorneys and the counsels must be very clear about what their case is. You can't approbate and reprobate. If you're doing that, you're really going to cause a lot of problems in your case. Your case must be based on a proper ground on law. Halfway through, you can't be changing the nature, the identity. You can't be going into saying yes and yes or no, creating contrary defenses. You cannot do that. And that will be detrimental to you.
And also, which is prohibited, so if I'm
It is
subject to
prohibited
correction,
under
is that
section 150, I believe.
150 explanation,
150
yeah,
of the Civil
150.
Procedure Code. Is it
Yes,
prohibited? You
150 is
cannot do that.
explanation too.
And please, when you are going to cross-examine the plaintiff, please prepare yourself a little bit more, or if not, prepare yourself. Don't just get up and ask questions that come into your mind just like that. Because I'll tell you one thing, ladies and gentlemen. If you are a counsel who does appeals, and when you're reading the evidence, not only is it an arduous exercise, it is actually a frustrating exercise. Because halfway through, you can see it is the cross examination that has driven you to defeat. So you have to be careful. I mean, we all are innocent in the law. There's no question about it. We
Yes,
all can be innocent and we are all corrected in instances. That is why continuous legal education is necessary. So it's very important to learn from practice. I'm not saying I'm the greatest. I also learn over the period of time. But I want to really emphasize this. Make, put your foundations clearly. And also please prepare your case before you go to court and the questions that you're asking. Sometimes, I'm just, Charita, if you allow me to say this, so
yes,
sometimes I think the counsel is playing smart in court by showing I can ask this. Just prepare yourself first because your case is based on certain foundations, right? Don't allow your ego to take over the entire case because it is not you trying to show the audience who you are. It is what your client needs. So please remember, you can't take contrary positions like that. And can I tell you also something?
yes, yes,
The credibility of the lawyer will be severely affected when you take positions like that. It shows that you're not serious. It actually shows that you're very unprofessional, I would think. Because you have to stand by the foundations of what you have taken up. It's very important. And I'm very thankful that you took up that question, Charita.
yes. So now also there is another concern as to a reivindicative action. Would it be an action, a personal action, or would it be an action in rem? I would say there is a misconception for whatever reason I have found and I have come across. For various reasons, it had been defined as a action in rem, and I believe you are the best person to explain it as to what the
I'm very happy you asked that question because we are in a period of time that the Honorable Supreme Court has really put this position clearly in the right perspective.
Yes.
For over a period of time, we have really thought that it is the duty of the plaintiff to prove his title. No doubt, that principle applies. But whether a plaintiff has proved his title actually has to be considered by looking at the entirety of the evidence. In very recent judgments from the Supreme Court, which I must say is very encouraging for land law, this position has been addressed. And actually, what is the purpose of the defendant giving evidence if his evidence is not necessary? So the evidence of the defendant can also be instances. Let's say the plaintiff's case is closed, but the defendant in the cross-examination can admit the title of the plaintiff. What happens then? So the defendant's evidence is very important to consider whether the plaintiff has proved his case. In other words, saying the totality of it. This whole misconception, whether it is rem or personam, actually also imposed that imposition that there's a higher standard of proof for the plaintiff. And I think there are cases that have been cited to show that in a reivindicatio case, it has been regarded as an action in rem in certain cases, such as Patirana versus Jayasundara. But in more recent cases, I might say cases such as Vasanta versus Premaratna, SC Appeal 176/2014, Asher versus Karim, SC Appeal 171/200. I have the case here. Asher versus Karim, it is 171/2019. And also Pinto and others versus Fernando and others, 2004-2005 BLR law report, volume 17, page 474, if I'm not mistaken. Volume 27, I'm sorry, volume 27. I think page 474. If I'm mistaken, I'm sorry. This is the citation I have. But the case is Pinto and others versus Fernando and others. It is the most recent Bar Association law journal, that law report that was published. It's in there where the Supreme Court judgment is cited. And there too, in all these three cases, you could see this changing judicial attitude is being adopted. I think it's very important to say that it's a very important change, and more than a change, a reassertion or a assertion of the correct perspective. So today, I think it is regarded as an action in personam. So therefore, only the parties who are bound by the decision would be the parties to the case. And a third party will not be bound by that because it's a personal issue, a personal action in personam. So it's very important to identify that.
So also at the beginning, quite correctly, you said you will take us through the concept of greater relief and lesser relief. I think now it's time, since we have covered most of the areas,
Thank
for
you
us
very,
to
very
give
much.
the prayer
Thank you
as
very
to
much.
what are the reliefs and where the plaintiff is
Yeah.
entitled to, and whether
Yeah.
he could get lesser reliefs or greater
Yeah.
relief.
Charita, this is one of the most wonderful things about our jurisprudence. You can file action on the understanding that the land belongs to you. But the evidence that you adduce somehow prove that you're only entitled to a share of that particular property. The question is, should the court dismiss your action so that a person who's a trespasser can continue in possession? If that happens, I don't think justice will be done. If that happens, I think there will be somebody who is taking advantage of the situation and the fact that he has not proved what he said and thereby stay in possession. So there is a long line of cases in our jurisprudence which says if you assert for greater relief, saying you are, example, you are claiming the whole land and you seek a declaration that you be declared the owner of the entire land in, let's say, in the schedule to the plaintiff. But you prove that you own, let's say, 1/24th share of that particular land. And in your evidence also, you admit that you are entitled to, let's say, 1/24th share. And the other co-owners are not before the court. But it's very clear that defendant is not a co-owner. And the defendant has entered the premises or the particular property and remained there illegally, encroached it, then the court will give you the lesser relief. That is to say, the court will not dismiss your case, but it will give you a declaration for 1/24th share in the property and give you an order or a judgment in your favor to eject the defendant who is a trespasser. Suppose if the defendant is a co-owner, your lesser relief can be a relief where there's a declaration of 1/24th ownership of undivided share. But there can't be a ejectment of a co-owner because that is not permitted under the law. That's very important. I want to also say in the line of cases, Charita, Heva Vitaranam versus Dungan Rubber Factory, Harriet versus Premasiri, Roslyn Hami versus Heva Gay Hami and others. But I found this particular judgment very, very elucidative. And that is Punchi Appu Hami versus Dingri Banda, which is Supreme Court Appeal 4/2010. Which is a judgment of Her Ladyship Honorable Justice Eva Vanasandra. In that, Her Ladyship explains what greater and lesser relief is. And I must also say that in the more recent times, in the case of Usher versus Karim, plus in the case, I believe, of Pinto, His Lordship Honorable Justice Samyavodana has also taken up this area and explained it thoroughly, and also distinguished very clearly, distinguish the application of a case, I think, which I think sometimes have been wrongly identified by parties. I believe that is Harriet versus Premasiri. The application of that case has also been sort of explained and distinguished, if I may use the word, in those judgments in explaining these greater relief and lesser relief. Actually, it goes on to say, if you permit me, I'm just trying to get the particular area in the judgment so that I can directly read from the judgment as to what greater relief is and what lesser relief is. Yes, greater includes less, His Lordship says. And also in the judgment, as I said earlier, it is important to talk about how this case, I'm sorry, it's not Harriet versus Premas Siri, it is the application of the case of Athanayaka versus Ramyavati, which is 2003, 1 SLR, page 401, that has been explained in this judgment and spoken as to what that judgment would apply, how it applied. And also Harriet versus Premasiri is also discussed in here. And this particular judgment, I think, is a very important, is very important because I think, if I'm not mistaken, this is the most recent judgment on that area of law. So greater relief includes the less too. I agree with that. And simply put, let me just recap. You ask for a declaration of the entire land that you have described in the schedule to be declared you as the owner. Number two, evidence led in the case establishes that you are only entitled to share of that property. Court will not dismiss your case. The court will give a declaration to that particular share. If the defendant is a trespasser, the court will give an order to eject him. If he is a co-owner, ejectment will not follow. I hope it's clear to my viewers too.
I believe so, sir. And since we have come to the tail end of the discussion relating to reivindicative actions, sir, I believe there'll be few other actions, type of actions, which we would, for the sake of completeness, to give out to attendees as to what would constitute a declaration of title or a definition of boundary or a possessory remedy. Those three actions, I think it will be much fruitful for the readers. Now, since thanks to your wealth of knowledge, I believe the attendees have been able to identify as to what is a reivindicative action proper. So therefore, for the completeness, let us also discuss the three types of categories I referred to.
Thank you, Charita. I must tell you, in my career as a lawyer, it took me until few years until I also found the distinction between these, especially declaration of title actions. And I think, it's quite easy for one to put everything in one basket and say reivindicatius. The reivindicatio actions, Charita, is clearly based on ownership. Essence of it is ownership. And it is filed for the purpose of declaration for a declaration that you are the owner of the land and ejectment of the defendant, who has no right to stay. Of course, under prescription, if he is entitled to prescription and proof, that's a different issue. A declaration of title, on the other hand, is an action that is filed based not on ownership, but on the basis of privity of contract. A person has a contract and you have entered my land subsequent to that contract based on that contract. And now I want you out. Therefore, it is important to prove that you are having a contract. Let's say if the other party agrees that there is a contract, now there is a contract. You have agreed. Now the question is whether you have violated my contract. If so, then you have to go. Sometimes in a declaratory action, there can also be a prayer seeking a declaration that you are the owner. The question arises whether that would be fatal to the action. I don't think so. These technicalities of, what you have prayed is the only one that you are entitled, also has been taken into consideration by His Lordship Honorable Justice Samyavodana in some judgments of the recent time, and especially even in Asher versus Kareem. So long as it is in the pleading and is manifest, then I think you are entitled to relief. I think that's very proper because the technicality will only prevent justice. So, if you take declaration of title, the essence is that there is privity of contract, a contract. Not the essence won't be the proof of ownership. You might be the owner, that's a different thing. But the cause of action is based on privity of contract. That's one. Then you will have definition of boundaries. A definition of boundaries is a case which is not a reivindicator. It is where there has been a boundary that existed between two contiguous lands, and that boundary had been obliterated. And a party seeks to re-establish the boundary. These three elements must come out in the plain, clearly saying there was earlier boundary existing. It was obliterated. And now I want it put back. That is the essence of a declaratory action. Sorry, that is the essence of a definition of boundaries action. That's very important. I'm sorry about the mistake. The definition of declaratory actions is based on privity of contract. Definition of boundary is based on the fact of existing boundary, obliterated. You need to re-establish the boundary. Possessory remedy is a remedy which is not based on ownership. It is based on possession. You don't go by way of possession. You don't go by way of ownership, sorry. You only go by way of possession. Let's say a party says, I have been dispossessed by the defendant, and that party has come before the court within 1 year and 1 day. Then you are entitled to have that case heard. And if you have been dispossessed and that is proved, you will be put back into possession. There, the question of ownership does not arise. The essence is possession and dispossession. And the third element, the time period that comes into being. So it's very important. Let me recap. Re vindicatio, essence is ownership. Once paper title is proved, burden shifts to the defendant. Defendant has to thereafter prove his possession. If he does not have a legal basis to prove that, he will be ejected. Plaintiff will be declared the owner of that particular land. Declaratory action. Plaintiff says there is a contractual obligation with the defendant, and if that contractual obligation is proved or accepted as to by the defendant and the privity of contract is established, then the defendant can be ejected for the breach of that contract and continuing to stay in that particular property. The fact that there is a prayer to be declared that he is the owner would not be fatal to that action. Thirdly, a definition of boundary is a case where one party says there existed a boundary between two contiguous lands, and now that boundary has been obliterated or is obliterated, and I want that boundary to be re-established. If those elements have been very clearly established in the plain, then you can proceed to hear a case on definition of boundaries. A definition of boundaries cannot be converted into a re vindicatio. That's very important. It cannot be. There's a very good judgment by His Lordship Honorable Justice Amaratunga. You cannot do that. Right? Possessory remedy, on the other hand, is possession, not ownership. And as far as possession is concerned, you have been in possession and you have been dispossessed by the defendant. And that dispossession has happened within 1 year and 1 day of filing the action. If that period of time has elapsed, then you can't come to court and claim a possessory remedy. Those are the distinctions of those three actions, which sometimes we put into the bag of re vindicatios, probably out of ignorance. And I think I myself has been a recipient of that ignorance, and I'm happy to, give some insight of what I have sometimes learned with difficulty in cases. I have had a similar situation once, I remember, where, well, that is why His Lordship Justice Amaratunga's judgment lingers in my mind. Actually, you can't convert a definition of boundaries into a re vindicatio. So you have to identify those things. So those are the differences, Charita.
So also let us remind, with your permission, sir, I have found
Yes.
the definition of boundaries, the three elements that you have set out, has been held by Justice Vigneshwaran in Demon Silva versus Silva, that is 1997, 2SLR 382, where His
Very
Lordship has
important
also,
judgment.
His Lordship has also considered
Sarita, thank you. Thank you. It's always not only a pleasure, it is certainly a contribution. I am very happy that you moderated this. Your participation has only enriched our, I don't want to say mine, our discussion.
Thank
It has
you.
been a great enrichment. Thank you.
Thank you very much, sir. So with that, sir, we have come to the tail end of our session, and I would like to invite the attendees. If you all have any questions, you all can post in the chat box, and or you could even raise your hand on the Zoom platform and ask any question as to related to the reivindicative action. since there are no questions that is coming up, sir, I think we had a very fruitful discussion. And
But Charita, there's
there's
one
one question.
question that is there by Diana Anthony. What is the remedy for a party who buys a land without knowing that another person, plaintiff's parcel of law, land is included in that land that he purchased due to the act of the plaintiff? As plaintiff purchase, sorry, it says plaintiff purchase their land and plaintiff built parapet walls without getting a survey done. So it's very important for you to, I think what is important in here, to type the answer. I think the issue is if you have bought a land and you don't know whether that land is inside the plaintiff's land, I think it's very important first and foremost before you buy the land to identify what the land is. And that can be done physically by going and looking at the land, all right. But you need to understand the parcels of land can be identified if you do a thorough title search. And in the title search, you can see if there are lands that have come in. Because sometimes you can say lot 177 of the plan will have several lands with several names. So you need to have a good title search done first, because lot of the people, they don't want to spend money on title searches, but later on they spend so much of money on litigation. Don't do that. First and foremost, do a good title search and see whether your title is clear. Then see whether there is a land relating to that title with the boundaries, and if the assessment numbers and all that are clear, you can. So if you haven't done that, then you will have a problem. So if it's the plaintiff's fault, as you might say, that all those things will come up in the trial, and you will have to deal. It's very difficult to give a answer right now on those circumstances without knowing the entire thing. So I'm just saying generally, it's very important to do a title search. I hope I was able to answer you to the best of my ability, because going into specific is difficult without knowing the entire case and to say something like that in a forum like this. I think that's the only question, Charita.
Yes. So since we have, then we can conclude, sir. I sincerely thank you for your time and everything. And it was my pleasure to have moderated this session. And I thank the Bar Association for the opportunity given to us. And I hope the attendees have taken the best out of it. And I would now pass on to Isuri for the
Just give
conclusion.
me a minute to say thank you to you, Charita. It has been a
Thank you.
great pleasure, not only saying because you told me that. I've been a teacher for the last 20 years, I've been a teacher in law. It's a great pleasure to see young lawyers like you who are very able, capable, and assisting the resource people. It's a real encouragement. And I wish you all the best in your future. And I also thank Isuri because she's been coordinating this from a
Yes.
few days. But please let me thank Mr. Rajiv Amrasekara for the simple reason I have had this conversation with the president over a period of time, way before he became president. These webinars are very important. And may I say, because I come from a provincial bar, it's very important to our provincial lawyers and the young lawyers. So thank you very much to all of you, and also to the president of the Bar Association and all members. And thank you for having me. It's a great pleasure.
Thank you, sirs. This brings us to the end of the first webinar of the new series on Basics of Law titled Re Vindicatio Actions. I thank our esteemed panelists, Mr. Sivali Amitirigala, President's Counsel, and our moderator, Mr. Charita Jaivikrama, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSF Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. And last but not least, I thank all of you who have joined in for this session through various platforms and for the interactive discussions that we've had. Thank you, and I hope you all have a good night.
Thank you.
Thank you. And